Welcome to Women Winning Divorce. I am your host, Heather Quick. I am an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. Our approach at Florida Women's Law Group is to provide women with a strategy to not only achieve their objectives, but win at life. I believe that what may show up as adversity is simply an opportunity to change and improve your life. In each episode, I sit down with innovative professionals and leaders who are focused on how you can be your best self before, during, and after divorce. In these conversations, we are looking at how women can win at life. I have the unique opportunity to meet women when they are at a transition period of life. But that is only the beginning to becoming your best self and winning at life on your terms. With our guests, we enjoy the opportunity to explore ways all women can win and enhance their life, no matter where they are in their journey. Because divorce is just a point in life, not the end and not what defines you, rather a catalyst for your growth.
Hello. Today, I'm joined by Beth Luna, magistrate for Clay County, Florida. And Beth is also the co-chair of the Legislative Committee for the Family Law Section of the Florida Bar. And for our listeners, our loyal listeners, Beth was on not that long ago on the show, and we were talking about the proposed alimony law that is now the law. So if you didn't hear that episode, you're going to want to go listen to it because now everything we talked about is the law. And Beth, thank you so much for joining us again for repeat performance so soon after our last show.
You're welcome. It's good to be here.
And, with these changes in for our listeners, we were talking just before, but really we haven't seen this many updates, changes in the law as it pertains to family law in many years. And so
yeah, I would say that this is the most we've probably seen in about a decade all at once. So considering that last year, like the big change was like, I think one little sentence, and this year you have so much across the board of different things.
Right. And it's very important. And for you listeners, I just want you to know the most important thing to know is the law has changed. So you need to be asking your lawyer how this affects you and with your pending case, or maybe, if you've had a case previously. And today we are going to talk about time sharing and the changes in the new law as it relates to time sharing, which is the time you and your spouse share with your children, formerly known as custody, but we refer to it as time sharing in Florida. And Beth, as a magistrate in the state of Florida, could you just share with our listeners a little bit about your career and how you got to the magistrate's office?
Well, I feel very lucky. I started off at Jacksonville Area Legal Aid many, many years ago. It kind of dates me if I tell how many. And I did a lot of domestic violence cases there in all family. And so I think that's probably where I really got the best start to my career in terms of trial work and just getting to know the law. And then I was in private practice for a number of years, both in Nevada and in Florida. And I actually did one whole divorce in Tennessee, believe it or not. So I laugh about that. I've practiced in 3 states individually. And so basically when I moved back here and went to work back, opened up my own office, I put in to be a magistrate and eventually got selected for the spot. I feel very blessed to have been selected because we serve at the pleasure of the judges. And I feel very lucky I'm in Clay County specifically because I have wonderful judges there that I work with, and the other magistrate is fantastic. So I'm at this point kind of at what I consider to be maybe the height of my career. I don't know. We'll see where it goes from here, but definitely enjoying the work that I do.
Well, and that's so wonderful to hear. And for our listeners, magistrates are hearing officers that really are on the front lines, so to speak, of what's going on with folks coming into court on family law issues and certainly child support issues and time sharing. So they are basically in hearings all day, every day, really dealing with all of these issues, whether it's with clients who are representing themselves or with other attorneys. So Beth is in a unique position to apply this every single time she's in the hearing room. Every day you go to work, you're doing this, right?
Yeah, we basically hear cases just like judges, and then we write recommended orders that the judge signs off on. So long as on its face, it doesn't look like we've made an error. And then just like a judge, you can file a motion to vacate if you don't agree with the decision. It's kind of like appealing our orders, kind of how I would reference it. But yeah, we do see a lot of self-represented individuals and a lot of individuals with attorneys. And I know that most of us are doing a lot of work in the time sharing area as well too.
Absolutely, which is a perfect segue into our topic today. So let's get right into it because Beth, it's House Bill 1301, and I believe it's titled Parenting and Time Sharing of Minor Children. And that really has altered, a lot for us here in family law in Florida because, again, like what you talked about, we haven't seen changes in a lot of these statutes in years. So, nobody likes change, but it was probably time for some things to get updated and modified based on some reforms and some things that hopefully are going to make things better for, families in Florida.
Hopefully so.
Let's get into it. Like, what's the biggest thing? What would you say for listeners, attorneys, everybody? Like, what's the biggest change to
Well,
parenting and time
I think
sharing?
it's everybody. That's a point of perspective. I mean, for me, one of the big changes was the removal of the word unanticipated. And I think for me, that change is just big because I think it has the potential to have a lot of really positive impacts for kids and for parents. I'm curious to see how it actually plays out over time. But that word was marked out of the standard to modify time sharing, which used to be a substantial material and unanticipated change of circumstances. It's now just substantial and material. And people may wonder why unanticipated was such a big issue, but it was preventing us from making some changes that were sometimes needed merely because they were anticipated. And probably a good example of that I like to point to is parents would come in with maybe an equal time sharing plan before the child started school. And when a child is, a year old versus the age of kindergarten, that may be more doable depending on where the parents live than it is when they get to kindergarten. And so I think with children, we would know what you need at 6 months and what you need in kindergarten, what you need at junior high, and what you need at high school age really can have a lot of differences. But that was an anticipated change, right?
Mm-hmm.
And case law also told us that we couldn't future predict. So when you were doing these orders, even a mediated agreement, you couldn't be like, well, there's some case law that says you can, but there's a lot that says you can't. You couldn't be like, in kindergarten, we're going to do a different schedule because it was future predicting. So by removing the word unanticipated, we're now maybe able to go back and look at those. You still do have to show a substantial and material change. It's not a free-for-all open door. So you've still got to have something in there that would let you move forward on it. But, there are other examples of unanticipated being a barrier, like the parent who was maybe on drugs or had an alcohol issue or a mental health issue that wasn't under control. They maybe reach a settlement agreement or the court orders something, and then there's no plan to get them moving forward. But they do get their life back on track. And somewhere down the road, that child's relationship with that parent maybe can look a little more normal than a supervised visit. And with the word unanticipated, there were times where we were saying we can't even fix that because it was anticipated that they might get better. So I think that's another place where we may see a tremendous amount of benefits where a parent improves themselves to a place where maybe now the child can have a more meaningful relationship. Again, still has to be substantial material. But I do think that unanticipated is, to me, a really big, much needed change sitting from where I sit. So.
And I appreciate that perspective from you because it is different than obviously our listeners or even as myself, and the attorneys as practitioners. And I do foresee that exactly like you're saying, because it is a 2-year-old needs different time sharing schedule than a 6-year-old, just because now where there's formalized school, like things do change. We know they're going to change, but it's exactly like you said. I think this opens an opportunity when you meet the other criteria that rather than a roadblock, which I think maybe that word previously did create a roadblock in areas where it would have been best. You could have met all the criteria to make a change for a child based on their age. That now will open the door somewhat, at least we will see. But I think that is going to be very helpful, certainly in cases as they move forward.
Yeah, I don't think all of them will qualify because, again, you've got that substantial material change. And then whether or not it's in the best interest of the child, I left that out. So you still got to go through those factors. But yeah, I think it's going to maybe help correct a lot of things that will benefit kids in the long run.
I think so. And like we said, it's more of a, for when it makes sense, because sometimes that word in and of itself was creating, it wasn't making sense maybe for what was best, but putting limits on what the court could do, what the
Sure.
attorneys could do. Now, so, right. And this is what goes into, because it's just like, oh, okay, hey, they're saying the law's changed. So now I can just go and try to get my agreement modified, right? But that's not it. It's got to be more than
No,
that.
it's still got that higher burden of proof. Once you get the final judgment, it is harder to modify those agreements, and I still think it's harder to modify. It just now maybe will let us look at some scenarios that we hadn't been able to look at in the past. So yeah, I'm curious to see. I had somebody tell me they thought it would open up the floodgates for filing, and I'm curious to see if it does that. I don't think it's going to, because I think you've still got that higher burden that's still there. You still got to show that it's the child's best interest. So I don't know that it's going to open up the floodgates. What I hope it does is give us some leeway to make some improvements in parenting plans that really benefit kids.
Agreed. And, just because it's the substantial change in circumstances that we have to get over that hurdle.
Yeah.
And that's where I think people, they don't understand. I mean, it's a legal term and it is the burden that needs to be proven. But oftentimes they're like, well, this is new. This is now happening, and it's like, but how substantial is that? And generally, if it's only been 2 or 3 months since your final judgment, it's unlikely, unless it's something very drastic, that it would be a substantial change in circumstances. Wouldn't you agree?
I would agree that most likely you're probably not going to have a substantial change. I mean, certainly it does happen, but there's still a lot of case law out there that never really looked at unanticipated, that talks about what's required for a substantial change. And so I think we're still going to lean into that case law very heavily. Again, I think it's going to be some extraordinary circumstance. It's not going to be just that simple things, right? Like, I can't think of an example off the top of my head, but anyway, it's going to have to be something that's substantial.
Agreed. And now, obviously, this applies when you're going to litigate and one person is choosing to modify, because if both parents agree to modify an agreement, they don't necessarily have to jump through this because they can come up with a consent.
No, and if it's, as parents, if you think there's needed changes and you both agree to them, that's a completely separate thing. You're probably not going to need to meet this burden. And I always say to people, I think, frankly, parents are going to know their kids far better than their attorneys, and far better than judges and magistrates. So if you're able to work together to make those agreements, presumably you probably are coming up with a better agreement because you've got the full picture. So I would encourage people where they can to mediate those things, try to come and resolve them without the court system.
Absolutely. Yes, because that is always faster and usually a better solution, because the two people who ought to know their children best in the situation best are actually coming to, an agreement. Now, here's another big thing that we know is all over the news. And, for many years, I was like, the law is not 50-50, but now the presumption, I guess, is. Is that correct? That's a huge piece of this bill.
There's a sentence that says that. I think my take on it is that this is not as big of a change as people think that it is. For one thing, I keep hearing all over the news and other places that it's in the alimony bill. It is not in the alimony bill. Your time sharing is not connected to your alimony. So if you look at the way it's written, it talks about there's this presumption created for equal time sharing. And then we have a discussion about how to rebut it, right? And to rebut it, it's a preponderance of evidence that it's not in the child's best interest. Well, frankly, that's what we've been somewhat doing for years, right? This is the lowest burden of proof. In the past, parents would come in. The statute very clearly says that we don't see mom or dad as having but more rights over the child than the other. It didn't use the word equal, right? And didn't use the word presumption, but there was this idea that they came in. We looked at them kind of the same or equally. And then we went through the best interest factors to determine what should be the time sharing. I think now we do start with equal, but we have to look, if you look at the way the statute's written, judges and magistrates, at the factors on best interest if the case is in front of us, and make a determination as to whether or not it is. And if a preponderance of the evidence suggests that equal time sharing is not, then we shift one direction or the other. Again, I think the word is scary because it says presumption of equal, but I don't think we're going to do things much differently than what we've done in the past.
And what is your thought as to, if really, like, at the end of the day, it does have to be in the best interest of the children. What was the motivation to, or the, I guess, anticipated outcome of creating a presumption that it starts equally?
I got to be frank with you. I don't really know what the motivation behind it was. And I say that because this was a legislative created piece of statute. They did this on their own. The family law section for many, many, many years has had a position that we don't believe that putting that language in there was a good thing, that it should be about the best interest of the children. We did come in with some additional language. And I think that language is what makes this, less. We're still looking at the best interest, and it makes that very clear. So I do think it was the intent of the legislature to continue to look at the children's best interest. So I can't really tell you what the motivation behind it was.
Well, and I think, and I don't know, obviously, you have more insight than I do, but I think, where you always hear a little bit more, maybe continuity throughout the state, because it varies so much, I think, on where you are in the state and different kind of local practices and whatnot, and maybe just to try to create this presumption, now codified in the law, that parents are starting equal. I mean, maybe I do see in practice closer to that than maybe what is reflected in reporting of the statute.
I think that there's it's hard to explain why it isn't equal when we talk about parents, one not having priority over the other, right?
Okay.
And I think it's very hard to explain that away to legislators and to people that are not lawyers. I do think the change they made ultimately still puts a huge priority on the children's best interest. None of the language that talks about the best interest of the children being a priority was removed. That language is all still there. So again, I think they're just making it clear that we're going to put parents on equal footing when they come in the door. That's my take on it. What the true intention was is between whoever proposed the language.
Right. Well, and it will be seen, how it gets played out over time. But
yeah.
This is a great time for a short break. We will be right back. And in the meantime, for our listeners, please take a moment to review our podcast, and that will allow others to find our content. We will be right back. We are back from our break. And again, today I am joined by Magistrate Beth Luna, and we are outlining the new time sharing bill here in Florida and what it includes, and really what that effect is going to be on the families in Florida. And so now one of the portion of the bill changes the relocation requirements. So Beth, let's talk a little bit about what it was before, and now what is this change that we're going to see in the relocation?
Well, I think the relocation statute still is its own standalone statute. The change actually occurs in 6113, and the relocation statute is 6113.001. Hopefully I've got enough zeros there. And that statute really did not change a whole lot, but what was added in 6113 was that if a parent is outside of 50 miles from the child and they move within 50 miles of the child, it can be a basis. It uses the word may, and I think people really need to note that word. A substantial change of circumstances. And so this was really kind of, I don't exactly know where it came from, but I get the impression it may have been military, and that they frequently move, and maybe they're further away and then they move back closer to the child. I mean, that really could be a lot of parents, but for example, military does tend to get moved around a whole lot. And so when they would come back closer to the child, now that was often an anticipated move. I think the striking of the word anticipated probably took care of this problem, even without the specific language, but that it was an anticipated move, and then they were stuck not being able to modify. So now a parent that does that can come in and ask to modify, and the court may consider that a substantial change of circumstance. I think it's really important to note that the relocation statute is still there. It still says that if you move more than 50 miles, right, that you need to file a petition for relocation. So I look at those two things almost separately. You might move, you might have been 50 miles away, but you move 40 miles back, and now you're within 50 miles of the child, but you don't need to file the petition for relocation. You could move 60 miles and still need the petition for relocation. So that's the interesting part about this, is you kind of got to know how far you're moving. You need to know if you're going to need to file that petition for relocation, because it's required in some cases. And then, you've got the possibility that this is a substantial change of circumstance.
And do you think, because this is an important change in mostly, I think, in allowing somebody, really, they're seeking more time, generally speaking, because you're further away, For our listeners, we have long distance guidelines. And so typically the further you are away, it's just impractical to have a lot of time sharing with your child when you
Well,
live
and
further
the
away.
summers is typically where they get the bulk of the visits when they live
Right.
far away. And so if you move back within, if you don't change that schedule, you may have that parent living down the street from the child and they've got the entire summer and the other parent doesn't have a bigger portion of the summer. So I think for both parents, there's some really good adjustments that can be made when they're living closer together. That might not have really worked. It might have really worked well when they were living far apart, but it doesn't work so well when you're close. So yeah, I think it's a good thing to take a look at these cases if it warrants looking at.
And just since you touched on the relocation, because so many people, I think, on their own get this wrong. At least from a perspective, you see it probably more often than we do, but sometimes we get brought in and it's like, oh, you guys did this all wrong. And somebody moves back and they don't realize, oh, I do have to go through the courts, if they're not getting along and have worked it out. But, when the parents move and they want to change their time sharing schedule, they've got to file something, right? If they don't agree with the other.
If they're more than 50 miles, yeah. I mean, the relocation statute's got some very specific terms that have very specific definitions. Like a relocation is 50 miles. You need to file this if you have a court order on time sharing or a pending case. So, you got to be very specific. And then it goes all the way down to defining what parents are. And so I do think people have got to be really careful on this. The need to file the relocation follows the parents, not the child. Some might argue that's a glitch in the bill. So it doesn't matter if you are the majority time sharing parent or not. If you move more than 50 miles and you qualify to file the petition, you need to file it, right? Or have an agreement with the other parent. There's a provision for that in the statute too. This is one place where it's really easy for people to foul it up if they don't understand statutory construction. They don't understand the nuances of that statute. And it's an area where I think people would be well served by having an attorney help them through at least the initial filing of the petition for relocation, because it's full of pitfalls.
And especially when you don't have the majority of time and you move, it seems very often they have not filed anything. And, we end up in court and, it's like they don't really understand that they had to.
Even filing that petition, if you look at it, there's like all these specific things in it. And if you don't, it says that you must strictly file that stuff in the statute. It must strictly say these things. And, it's really, I don't like recommending that we deny something on the basis that something was just not in the petition, right? It just creates extra work for everybody and slows maybe the process down where there's a needed fix. So yeah, it's very specific.
And it is, and that kind of goes to the next thing that, in this statute, and frankly in a lot of them, but that findings and factors are mandatory. And, and we understand like what a big deal that is, but if you could help explain that, one, how that's different than before and why that matters to our listeners.
So it's interesting because when we do orders, if you look at appellate cases, they are frequently sent back to the circuit court or the magistrate for failure to find findings of fact. And so we know for a long time that the DCA, the District Court of Appeals, they like their findings of fact. And I do think it's beneficial for parties to have good findings, because when you go to modify, be it child support or alimony or time sharing, those findings set the line for where you were at that time, right? So all over a lot of the bills that passed this year is a requirement for findings of fact. 6113, the changes into it say very specifically the court must make specific findings of fact. And so I'm now doing that in temporary orders and final judgments. They added a new factor. I'm happy to touch on that too, that goes into that. And so, those findings of fact are so important for you down the road and in terms of making an order that doesn't get overturned by the District Court of Appeals. So I think the legislature heard that and they put findings of fact all over the place. So.
And let's talk about the new factor that you were talking about, but it does. And sometimes, what we tell our clients, and especially, they bring us an order that may have been done in the past, or you're evaluating an order that they're trying to change, enforce, or many things. And without those specific findings and those facts, it sometimes can make it so much harder for you to show the change. And so I think that that's really better for, for families in the long run, like you said, and when a decision is rendered, it is clear. Now it really has to be clear why.
Yeah.
Why did the court make this decision? Which that tends to be very often clients' questions. Why?
I mean,
Why?
the most simplest places think about child support, because you're often looking at whether or not there's been an increase or decrease of income. So if the parties' incomes are not in the final judgment and you want to modify it, then how does the court know what the difference is between the original to where you're at now, whether it's increased or decreased? And that, believe it or not, is more common than you think to see in final judgments where those numbers are just not there. I mean, alimony gets impacted. And again, that's just a numbers game. So I really think it's important to make sure you're getting plenty of findings of fact, even if your attorney's drafting the order or if the court's drafting it. And now I think we've got very clear instruction that we are to do it. Right.
Yes.
So, I can talk about the changes in 6113 on the best interest too, if you want that.
I would love to get into that. Yes.
So that's in Grayson's Law. And Grayson's Law, for people that don't know, is named after a child, Grayson Kessler, who was murdered at about 4 years of age by his father in apparent suicide. And it was a tragedy, to say the least. His mother, Allie Kessler, really went to the legislature starting last year trying to pass Grayson's Law. And then this year it did actually get passed. So this bill is named after him. It looks a lot different than it did last year, but it does add, it adds factors to the domestic violence injunctions for protection against domestic violence and to 6113. And it does two things in 6113. There's shared parental responsibility. So it adds some things for the court to look at and determine whether a shared parental responsibility would be detrimental. And that includes if there's evidence of domestic violence, if either parent has reasonable cause to believe that they or the minor child have been or are in imminent danger of becoming a victim of domestic violence. That language, that was already in the injunction for protection against domestic violence. So now we're just pulling it over into 6113. And then whether or not abuse, abandonment, or neglect by the other parent, that's something that we see in Chapter 39 a whole lot, which is the dependency chapter, or any other relevant factors. So there is a catch-all at the end of this. So those are things now in looking at whether or not we should be doing shared, the court has to consider as well. And then in the best interest factors that the court has to consider in time sharing, there's now a 13th factor, and that factor has actually already been there, but it adds additional language that comes back to that language of evidence that a parent has or has had reasonable cause to believe that he, she, or his or her minor children are in imminent danger of becoming victims of an act of domestic violence. So it's going to look at imminent fear, and it looks at whether it's the parent or a child, and that doesn't even have to be the children of the marriage, or the relationship. It could be, a stepchild that they have that fear for. So I think it kind of really opens the door for the court to take a harder look at domestic violence cases, that you can be in fear of it, right? It does have to be reasonable, imminent fear, but you can be fear of it, and the court can take that into consideration.
Which is, I think it's really important, because those are the worst, and that happened here recently in our jurisdiction in Northeast Florida last year. A murder suicide, the father, and it happens entirely too often. And sometimes the victims of domestic violence, they are afraid that they don't have enough, they don't think, right, to, like you said, to show, but they know, like, within themselves, they're terrified, and they have this fear, and it should be considered by the court, and certainly in time sharing, without a doubt, in addition to the domestic violence statute.
It's kind of interesting that it's always been something that we looked at for injunctions. Right. And then, you would look at, as you were doing time sharing, you would look at whether or not maybe there's been an injunction or domestic violence, but never the specific language had never been pulled over. I kind of like seeing it in the statute, because I think now it gives the real consideration to how did we get here, right? Whether there's an injunction or not, it still lets the court give some consideration to that. So,
and because it is relevant, it's so very relevant. It's so, it should be considered in the parental responsibility and those things, not just like, okay, well, now they're separated, divorced, as if the children whether or not they were the, subject of violence, they were in that household. Like, I think it's important that the courts do take a bigger look at it and a closer look, not just saying, oh, okay, now you guys are separate, and oh, it was just the husband wife, as if that doesn't still affect the child, and maybe dig in a little bit more on that.
I think it's good legislation, and I'm curious to see how it plays out. The domestic violence statute on injunctions got some additional language from Grayson's Law too that's more extensive than this. That's going to look at like patterns of control and some things like that. I'm curious to see how that plays out as well too. That particular set of language has got a lot of pieces to it, including the reasonableness of it. Was there a pattern? Was it over time? A lot of different things. So I'm curious to see how that plays out in particular, since I think it kind of adds an extra level to those cases that we've not had in the past. Hopefully this will let us protect victims and children in a better way going forward.
Yeah, and I think that is important for our listeners to know, because often sometimes they've been in domestic violence court and felt, just like they didn't hear me, or I was scared. I just didn't know how to articulate what was going on. And so I'm glad to see that law has added a few more layers that can allow, and hopefully the judge, can hear that, inquire more. Particularly, very often they're self-represented in those hearings, and they don't always know.
No, they don't always know
just how to communicate this fear, because it's intimidating in the courtroom, and it's a lot very often, but it's one of the only tools that we really have for protection, because it's protecting, what the unknown is, right, in the future. And so it's so important, though, I feel like, for those victims to have that venue. So I'm glad to see that it has expanded a bit. And I'm hoping that, saves more lives and prevents more of this violence that we still continue to see.
Yeah, I hope so too. I think it's a positive change. And again, I always look forward to seeing how these things play out in the courtroom, because you just never know. But I'm curious to see how they.
I know. I'm gonna book a date. We're booking a date for next year. I don't know how much we'll see in the next year, but we will see some cases follow through, and we're gonna have to do a recap, like a year later. Where are we on these laws? But we're going to take another short break, and then we will be right back. And if you are enjoying this show, we just ask that you subscribe so that you always get a notification when a new episode becomes available. We will be right back. We are back from our last break. And again, today I am joined by Magistrate Beth Luna, and who is also on the legislative committee of the Family Law Section for the Florida Bar. And what that means is she has been intricately involved in the drafting, creative, modifying of the new laws that are now in place here in Florida. And today we have been talking about the new time sharing law and what that means for parents here in Florida. And we've talked about the change of the unanticipated. We've also talked about the 50-50 and a little bit about, moving. What would you say, Elspeth, is like something big that our listeners should know as far as like an overall change they should be aware of?
Well, just in terms of those three, or any other changes that
any other changes that they should really.
I think the other one that kind of impacts time sharing is the bill on the natural guardians of the children. Let me pull it up so I can better tell you. So that bill, basically, in the past, where you were unmarried, the mother was the natural guardian of the child, and it now creates both parents as natural guardians under certain scenarios. And that's where an affidavit or an acknowledgement has been signed. There's some very specific things. Oddly enough, I will point out to you, it's not just the name on the birth certificate. You got to have that acknowledgement with the birth certificate to make it qualify. But, in the past, in those cases, courts might say on an emergency level, we're not going to address this because dad is not a natural guardian and mom is, or we're going to issue the pickup order because dad is not a natural guardian and mom is, and dad has the kids. Or in injunctions, you would see where the court would maybe say, I'm not going to address time sharing because dad is not the natural guardian and paternity hasn't been established. Mm-hmm. I think this is placing dads kind of on the same footing in some scenarios as a husband and wife. I actually think this is a positive change, and it's kind of a modernizing, I would say, a little bit of the statutes in terms of how we view those fathers, because they have acknowledged paternity in some very formal way. Um, I'm again very curious to see how this plays out. I think it is got some probably good impacts. Does this mean that you can't get emergency orders anymore? No, it doesn't mean that at all. It just means that you're going to have something that rises to the level of an emergency, right? And
Right.
you really probably needed that in the past too, but it's not going to be just, hey, mom's natural guardian and dad hasn't acknowledged paternity if these things exist. So you need to know if you're unmarried and you have a child with somebody else, you need to know, is that person on the acknowledgement with a birth certificate? Have they signed an affidavit? What have they done to acknowledge, and does it qualify underneath the statute? So that's one big change that I think a lot of people just don't know about, that's going to have some trickle down impacts as we go forward.
And I wonder this, and you may know the answer, because as you're going through this, and my experience is only personal, but they come in and ask you to fill out all the stuff on the birth certificate. So do you think that they're going to offer that acknowledgement to the fathers in the hospital, or is that going to be required for the father to seek that out? Do you have any idea?
I don't think that there's any changes to the way that they've been doing it in the hospital in this bill.
Yeah.
And I'm going to be completely frank with you. I have no idea what that looks like in a hospital, because I'm a dog mom. And I hate to admit that, because I know people will be like, oh, you don't have kids. But I mean, I'm certainly well educated on a lot of things with
Yes.
children as a result of this job. So it's interesting, because having not ever filled one of those out, I'm not even really sure what it looks like on the ground. I
Because
do,
that's a lot of logistics, because they have their form, they have what they have to do in order to
yeah.
submit for the birth certificate. And I'm just curious. I wonder.
So it was one of the questions when we spoke at a CLE in front of a bunch of family law attorneys about a couple days ago. Now it's not been that long. That was
Mhm.
one of the questions I legitimately had. Does every birth certificate have an acknowledgement on the back of it? And it turns out they don't. So, if you don't know, you can request it and they will send it to you with the acknowledgement. Be very specific. And I need the birth certificate and the acknowledgement if it exists. And then you'll know for sure that it's on there. But,
Mhm.
there are other ways to get there. Like, apparently the parties can just sign an affidavit. I mean, which was surprising to me. That's been in the statute for a long time.
Mhm.
I didn't really recognize it was in there until we were preparing that CLE. And I was like, whoa, apparently you can just do an affidavit. You can file an affidavit with the clerk of court acknowledging paternity. So paternity gets acknowledged in a lot of different ways. Besides just the acknowledgement on the back of the birth certificate. So you need to know, if you've signed something and you hire an attorney, let them know what you signed and what the father signed.
Yeah, because it's one of those things. We've had paternity cases for years. They're very challenging, because I think that the I don't know. I don't even know what the perception is anymore, frankly, than from 15, 20 years ago. But that, well, what legal rights do they have? But it's like, well, you've been with this person, that is, you acknowledge they're the father. So just some of your, as a parent, it will come back at you in front of the judge if you aren't trying to help establish that relationship. Has been my experience. Even if before this, or there is no acknowledgement, there's no legal rights as far as enforcing anything with law enforcement. But the fact that now we're trying, I think the legislators making it a little bit easier, so that maybe the father doesn't necessarily have to go to court to establish that that is his child. And a lot of mothers don't understand that or know, and think that they can do whatever they want. And I think that just unfortunately, sometimes it gets really sticky, and in a drawn out court battle, and it can come back against the mothers. And they really just didn't know. They didn't know that.
Well, and I think that there needs to be education about the statute, because I think while lawyers may know it, like, non-lawyers are not going to necessarily know that this change happened. I
Right.
suspect that, like, law enforcement's going to need education on it, because, having been in private practice where sometimes law enforcement gets involved. If you've got a husband and wife, they might not remove the child from either one of them. And I think now you've got some scenarios where that really should be the way it plays out. But whether or not law enforcement is aware of this, I mean, they're going to get education on it just like attorneys are, but then the general public needs to be aware too. So that when you are in that room with the child and the acknowledgement and you put a father's name on it, just know now it carries a little more weight than what it used to. Right.
Exactly. And yes. And so when you do that, you need to be sure of what you're doing, but also understanding now some rights are attached and they're maybe just not as much of a roadblock. You still may have to go to court. And with that, just kind of looping back, that time sharing applies. It's not just to married couples with children. It is children between two parties. So I think that's a huge education for many women. Well, we represent only women. So that's how I speak from that perspective, obviously, because those are our clients that we talk to all the time, but they don't recognize that, wait, we weren't married and still it's presumed that, my baby is going to be shared 50-50 and that's the way this is going to work. And that's the harsh reality and truth of the laws. And
well, and
not a prerequisite to time sharing.
Right. So you still have, just like, a married couple who's divorcing, you still may have to file a petition. Yours is not going to be a petition for dissolution of marriage, but it may be a petition to establish parental responsibility and time sharing in a parenting plan. Right. You may not have to establish paternity because that may already be done, but you may still need those court orders if you can't reach an agreement on it as to what that time sharing schedule is going to look at. And you're right. It's absolutely going to go back to what we talked about earlier, the presumption of equal time sharing. Is there a preponderance of evidence to suggest that it shouldn't be that because it's not in the best interest of the child? Right. So you'll still have those steps where you might not have been aware of that back in the day before July 1st. You wouldn't have had
July 1st, but exactly. And, and just to reiterate what you said before, because I've certainly seen this in practice as well, although it wasn't written in the statute, the presumption, it has been applied in practice by many of the courts in our area, Northeast Florida, in paternity cases as well. And sometimes even more, I found, which kind of boggled my mind, like a family that lived together that were married may not have ended up in 50-50, but sometimes paternity actions tended to be more so just for whatever reason. But so it was being done in practice very often. It's just now in the statute that there's a presumption of equal.
It definitely, I feel like over the years of being an attorney, and I don't want to date myself too much, but I do feel like there's been more and more of a move towards equal. And more people are agreeing to it too. It's not just the court system that's doing it. I understand down in South Florida that 50-50 has kind of just been the standard for a long time. I don't think it's as much in North Florida. I think we tend to look a little different. But I do think the trend has been definitely moving where more and more parents actually are actively seeking it out, having that. And even the local guidelines, they're 40-60. They're pretty close to 50-50.
It really is. Yes.
Yeah. And I think you're still going to see the local guidelines a whole lot here. I mean, they really work for some people better than 50-50. Depending on the scenario that you're in, obviously there's a lot of criteria that we look at in determining what's in the best interest of kids. So, not all schedules are created equal.
Exactly. And not all are, ideal.
It's kind of a funny way of saying not all schedules should be equal, but not all schedules are created equal, nor will they be equal.
Exactly. But they've been trending for quite some time, almost equal anyway. And again, I think obviously everyone's particularly facts and particular family, go into that as well as what's best for the children. I know there's another part of the bill, and we touched on it earlier about the time sharing schedules that are agreed upon by the parties. And it says, and approved by the court, do not require evaluation or findings of fact. Like, what does that really mean to our listeners, though, who probably don't always understand legal writings that often?
Well, it's interesting to me because I'm like, well, what does approved by the court require? Like, is that just that the court signs off on it? Is it that the court because in the past, when you brought like final judgments that were mediated and agreed to the court, they were still required to make these not necessarily written findings, but findings that it was still in the best interest of the child. That seems to be that specific requirement that the court find the child's best interest is not there. It's approved. I assume that means a court could elect to not approve it, but the reasons they would do that are not spelled out in the statute, right? That's pretty clear to
Mhm.
me. But yeah, in those cases, you don't have to go through the best interest findings of fact. And I find this interesting because I do see it as a little bit more of maybe, I don't know that it was intended to be this, maybe that we're acknowledging that parents should be able to make parenting decisions
Mhm.
about their children, and that maybe we should acknowledge that those parenting decisions maybe are the best, right? Because again, as I say all the time, parents know their kids better than I'm ever going to know them, right? And so I don't know if it's an acknowledgement of that. I don't know the intent, but it's a very interesting sentence to me. I do think part of it was just that the court didn't have to make those written findings of fact. I do think that's probably played into it.
Right.
Again, I don't know what approved, what the requirements are on that. I'm guessing that if you look at a final judgment and you see something that's really putting up red flags, maybe then I don't know what that's going to be. I'm going to be curious to see if any of those end up in the appellate level.
I think so. It will be interesting because we've had experiences before where judges just would not sign agreements
Yeah.
that parents made in regards to their own children. And that creates that whole issue. Well, we're trying to say, parents, you should come together and come to an agreement because you are, the parents of that child, not the court. But sometimes they wouldn't, and for their own reasons and beliefs, and that's been for as long as, I remember back in the days, which will date me for sure, but I'm not going to say how many years ago it was, where there were certain judges that if you had agreed to 50-50, they wouldn't sign it, and they would require a hearing, and they would change the language. And I have a feeling you probably remember some of those back in the day because it was so foreign to us, I guess, up here in Northeast Florida, 20
I
years
think
ago.
there was some definite, clear directive in the past that the court had to make findings that it was in the best interest, and maybe not necessarily written findings as clear as it is in the
Yeah.
statute on some stuff now, but that it had to be in the best interest. So yeah, when a court saw something that maybe looked like it wasn't, I think that they probably did have some
Yeah.
duty to question that further. Again, I don't know how this is going to be played out. I'm suspecting I'm not going to see a lot of it because most of the time mediated agreements go directly to the judges to be signed without us in the middle of it.
Mhm.
But I am going to be curious to hear how it gets played out, if there's ever any that are disapproved and the reasons behind it.
Exactly. And then what's your recourse? So then what gets done? But
Yeah.
it will be interesting to see. And I think overall, well, I guess I'll ask you, what do you think overall these bills, in their entirety what effect do you think they're going to have on the families across the state of Florida?
I always hope it's positive. I really do. And I think legislators in general want to make good bills and they want good legislation because they're trying to help someone or they're trying to impact positive impacts. So that's what you really hope you see with these. And I think right now they're a little scary and new to people. Certainly the presumption created a little bit of with a lot of people. But I think when you really get down and hammer down on it, we're really just where we were at before, in terms of such a low burden to get past it, for one thing.
Yeah.
So I don't know. I hope it's all positive changes. That's what I hope. And I hope a year from now, we're happy with these things and they're working and making sense for families.
Well, we still appreciate you today, Beth. And I guess lastly, I'm going to ask you if you can impart on our listeners, which you've given us so many helpful tips already, but how should they navigate this new normal? What would you advise to listeners, in family law court?
Well, I think having counsel can really be a benefit, but I recognize not everybody can afford that. And, there are resources out there. And that's what I would say. If you're not sure on something, try to locate Jacksonville Area Legal Aid or get to one of their clinics or Three Rivers, which is here in this community as well, too, to try to get some legal advice to help you. The forms online are obviously going to need some updating from some of these changes. And that does take a little bit of time, but the forms are usually pretty helpful, too, in terms of that. Educate yourself to the best of your ability and, get good advice where you can get it. It may be worth paying the consultation fee just to get some decent, solid advice on what you should and shouldn't be doing.
Well, and that is always good advice, Beth. So thank you so much. We've reached the end of our show. We really greatly appreciate you giving us your time today, especially since you gave us so much time just a few weeks ago. We really appreciate it. There's just so much changes going on, and it's really helpful to talk about it and hear from someone who was so involved in it.
It's always nice to educate a little on this stuff post.
Well, and it's helpful. And I think hopefully can decrease a little bit of the anxiety and fear that many people who are in, especially when you're in the middle of the case, right? People who aren't involved in this type of situation in court, they have no idea what's going on because it's not within their frame of reference. But if you are in the middle of litigation or have previously been divorced, some of these things might really cause you a lot of concern. And I hope that this helped, reduce that fear and anxiety of the unknown for so many of our listeners today. And we appreciate it.
Thanks for having me.
Oh, of course. I know you'll still. I'm glad you still said that because next time you may be like, stop calling me, Heather. I'm not going to be on the show anymore. But we won't pester you too much, I promise. But if you or someone you know is going through divorce or is thinking about a divorce, of course, reach out to us at FloridaWomen'sLawGroup.com or join our Facebook group, Women Winning Divorce, where we are bringing together a community of women to talk positively about the changes in their life. And the link will be below in the show notes. As well, if you enjoyed this show, we would request that you leave us a 5-star review, and we thank you for listening.
Interested in joining a team of passionate and powerful women? Here at Florida Women's Law Group, we're hiring a family law attorney and legal assistant. To learn more and apply, go to FloridaWomen'sLawGroup.com. Divorce for women by women. Non-attorney spokesperson. Offices Jacksonville.
Thank you for joining me for this episode of Women Winning Divorce. My goal is to elevate your life and the way you are thinking so that you are best equipped to win at life. If you enjoy the show, please subscribe so you automatically get my new shows every week. And I would love to hear from you personally. Come join the conversation on social and join our Facebook group, Women Winning Divorce. We welcome your comments and suggestions. We want to bring you content that helps move your life forward. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.